Made, please. Well, it's a dismissal of a writ appeal. Lord, we missed the list. In fact, that is the reason why we couldn't appeal. My lord. The same appeal is for restoration of the writ appeal. In the writ appeal, there was an interim stay as well. My lord, unfortunately, there is some delay in filing the same appeal. The delay is, my lord, reasonable amount, my lord. Reasonable days of delay, my lord.
How much delay?
My lord,
9 days. What's the main matter about?
Well, so far as the writ appeal is concerned, well, here the land was allotted in favor of the present petitioner by virtue of a provisional allotment by Rourkela Development Authority. Well, there was a notice issued, demand notice issued for payment of the fees that was challenged before the Honorable Single Judge. In the demand notice, there was opportunity to show cause, but at the same time, there was levied of penalty. On that ground, we challenged before the Honorable Single Judge. The Honorable Single Judge, by the impugn order, has said that 50% I have to deposit, then file a show cause. Challenging that 50%, we had come before this Honorable Court in the writ appeal. This Honorable Court in the writ appeal was pleased to stay so far as that deposit of 50% is concerned. Now, my lord, here I would like to submit, my lord, in the meantime, during dismissal of the writ appeal and CMAPL, there has a lot of developments. My lord, the development is pursuant to the demand notice, there has been another fresh demand notice. So in my humble submission, that demand notice has become infructuous with reflux of time.
Then why press for all this?
Only my respectful submission is, if your lordship disposes of the writ appeal, if at all CMAPL is allowed, dispose of the writ appeal, granting me liberty to assail my the fresh demand notice in appropriate forum.
We can do it here itself. You say counsel for the petitioner informs the court that even the writ appeal of restoration which is sought may not survive because of the subsequent developments where a fresh demand has been raised. Full stop. It will always be open to the petitioner in case there is a fresh demand to challenge it in appropriate proceedings. Full stop. Consequently, the court is not inclined to recall its order. The application is dismissed.
If your lordship, that liberty, my lord,
then the delay is condoned to 7-5.
That liberty, my lord.
I have said
Oh, bless you.
Item number 2.
Please, your lordship, my lord. I am in a busy mood, my lord. My respectful submission, my lord, with due diligence, the impugned order by Annexure 1, my lord, that is running page 14, dated 6/11/2019 is hereby challenged, my lord. The order passed by the Lord Single Judge. So far, the case is concerned, my lord, in Northshell, the case is like that, my lord. So far, the post of the Shiksha Sahayaka, my lord, the advertisement that was came into light on, my lord, 13th October 2006, my lord. The humble petitioner, being the inhabitants of the Mahakalapada GP, my lord, applied for the post of the Shiksha Sahayak, my lord. But the law is also to express that the illegality has been done because the outsider, those have no resident at all, so far the Mahakalapada GP is concerned, they have applied and they have selected. However, the humble petitioner, being the, my lord, the inhabitants of the Mahakala GP was also not selected. That's why this a series of writ application moved before your lordship having the single bench, my lord. All the single bench orders, my lord, inter alia contended that the petitioner's representation should be considered, and the outsider, those have no right, they also be considered, including the present petition. So far, the Annexure 1 is concerned, please make a glance, my lord. The order passed by the Lord Single Judge.
Your writ appeal is obviously time barred, and you have not even filed an application for condemnation of delay.
My response submission, there is a series of writ application orders also passed by your single bench before your lordship, my lord. All the single bench orders I have also quoted, my lord, in my plaint also, my lord. So far, the first writ application is concerned, my lord, that was registered, my lord, in the year 1911, my lord. Since till today, my lord, the series of writ application pending, and inter alia, your lordship, your single bench also granted liberty to file one after another this present writ application filed by the Annexure, and that has also been challenged.
Not even the.
I don't think you're answering the question, sir. Have you understood the question, or you're simply saying whatever you want to say? Have you understood what I asked you?
My lord, so far the delay is concerned, my lord. Delay, limitation petition. I may permit to file a limitation petition, my lord.
Not now, sir. This matter was filed when 2020.
My lord.
Ah.
So I humbly pray I may be.
After 2.5 years, we don't propose to grant you more indulgence for that. Yes. You see, the appeal is obviously time barred.
My lord, matter
the appeal was filed way back on 2nd June 2020 against an order dated 6th November 2019 of the learned single judge. For more than 2.5 years now, counsel for the appellant has not even bothered to file a certified copy of the impugned order, and was still not even an application for condonation of delay. The court does not propose to grant any further indulgence to the appellant. The writ appeal is dismissed.
Item number 3.
Yes.
Item number 3.
May it please, Your Lordship. Lord, I had prepared a compilation, a convenience compilation for Your Lordship. Can we, Lordship may not open the brief, but convenience compilation tab. This is a review arising out of a division bench order, my lord, and my prayer is extremely limited, my lord. Lordship takes the convenience compilation for a moment.
Yes.
My lord. Lord, this is a case wherein the two workmen, my lord, were employed under the Orissa
Compilations.
Uparach. Lordship has got the compilation, my lord?
Yes.
My lord. These two employees, my lord, were employed under the erstwhile Orissa State Electricity Board, my lord, as casual workers, my lord. And this was way back in the year 1984-85, my lord. I came into the picture in the year 1995, my lord. Lordship takes the date chart I have prepared, and why I am before your Lordship, my lord, in this review. May I take your Lordship through the date chart, my lord? My lord. Serial 1, my lord. 1984 to 85, OP number 2 engaged as a casual worker under the predecessor of Gridco, that is Talcher Thermal Power Station, Orissa State Electricity Board. But in the past, Talcher Thermal Power Station was a unit of the Orissa State Electricity Board, which was taken over by an act of the state legislature by the National Thermal Power Corporation. All the assets and liabilities of erstwhile OSCB stood transferred to NTPC in terms of the act. Now I'll come to the act, my lord. So, once I place the date chart, my lord. OP number 3, my lord, was never engaged as a casual worker under the predecessor of Gridco, that is Talcher Thermal Power Station. 17/9/85, OP number 3 failed the interview to be appointed as NMR in Talcher Thermal Power Station. 14/92, employment to OP number 2 and 3 was refused by the management of erstwhile Talcher Thermal Power Station. Claim of OP number 2 and 3 is for the period prior to 1/4/1992. For 24/5/94, reference under section 10 of the ID Act, where the reference read, my lord, whether the refusal of employment to Akhil Kumar Sahu and Mahananda Saman with effect from 1/4/92 by the management of Talcher Thermal Power Station, Talcher is legal and or justified. If not so, what relief, my lord? At this point in time, my lord, Orissa State Electricity Board was in existence. These persons had their claim against Orissa State Electricity Board, and the reference was also Que Orissa State Electricity Board. 1994, ID case number 113 of 94, instituted against the predecessor of Gridco, that is General Superintendent, Talcher Thermal Power Station. Serial 7, my lord. 1/4/1995, Electricity Reforms Act comes into play, my lord.
So you're coming, seeking review of this
order. Now the order, my lord, is
just gives them 90,000 as compensation.
That's right.
Against that, we've come in review.
I am obliged, my lord. My lord, I ask myself the same question, that when the amount is so meager, 90 plus 90, why should NTPC come before your lordship and seek a review, my lord? My lord, there is a statutory bar in the Acquisition and Transfer Act, which says that all the assets and liabilities of prior to the appointed day will be with the corporation, and then will are transferred to the state government. It cannot be passed on to me. My humble submission in this review is the successor in interest of the Orissa State Electricity Board be directed to discharge this compensation, and there were two orders of this honorable court which said, which directed the
concern. So NTPC will end up spending more than 5-10 lakhs on the litigation, but I can't pay the workman 90,000.
It's not on the issue.
Yes, absolutely.
It's not on the issue of workman. I'm conscious of your lordship's view, my lord. Here, my lord, is the case. My lord, the floodgates will open one side. Kindly see section 3 of the Act.
Yeah.
I have annexed the Act. Kindly see section 3 of the Act.
Yes.
That's at page, my lord. That's at page 13 of this compilation. It starts at 12. At page 13, my lord. Page 13 of the Act, but for the statute coming in the way, I would not have pressed this petition. Kindly see page 13 of the Act, page 13, that's in the compilation. Section 3, my lord, may I place section 3? It reads acquisition and transfer.
All permissions to place everything, sir. You don't have to ask every time. Please go ahead. Yes.
On the appointed day, my lord, the
Yes.
appointed day is 3/6/1995 by notification, my lord.
Correct.
The power station and the right, title and interest of the board in relation to the thereto shall by virtue of this act stand transferred to and vest in the state government. Section 3 says, my lord, everything will vest in the state government prior to it being transferred to me. The power station shall be deemed to include, etc., etc. I'll skip that over, my lord. Relevant lordship will find at section 5, my lord, the power station vested in the state government under section 3 shall on such date as the state government may by notification specify in this behalf vest in the corporation free from all encumbrances, and thereafter the corporation shall become the owner of the power station. Land measuring, etc. Section 6, my lord, which is the statutory bar. No liability of the board, which is the Orissa State Electricity Board, my lord, in relation to the power station incurred prior to the appointed day, and no award, decree or order of any court, tribunal or any authority in relation to the power station passed after the appointed day in respect to any matter, claim or dispute which arose before the appointed day shall be enforceable against the corporation. My humble submission is, my lord, the reference was qua OACB, successor being Gridco OPTCL. The Honorable Division Bench in the second round of challenge directed the management of TTPS to pay. The management of TTPS as on that date, my lord, was OACB Gridco and OPTCL, my lord. My humble submission is, my lord, your lordship be pleased to modify this order to say that the compensation amount will be dispersed by OPTCL Gridco, and if not, it would be the state government would be liable to disperse this compensation. That is the only modification I seek to this impugned order, my lord. The impugned order, my lord, relevant is that I'll place the impugned order. Lordship will kindly see the impugned order, my lord. In this compilation, it is at page. I'm not going into the fact that before the industrial court, my lord, OPTCL was not noticed, Gridco was not noticed, there was denial of opportunity. This is despite the directions of the Honorable Orissa High Court. Kindly see, my lord, page 47. 47 of this compilation, which is the order impugned. Therefore, taking into consideration the fact that due to efflux of time, the workmen have almost reached the age of superannuation. So possibility of reinstatement with full back wages is ruled out. Therefore, to subserve the interest of justice, we direct the management to pay a compensation of 90,000 each in lieu of reinstatement in service within a period of 8 weeks. My humble prayer is, my lord, the management of TTPS here, as revealed, my lord, at page 43, would be, my lord, opposite party 4 and 5. It cannot be saddled on me, my lord, because there's a statutory bar which operates, which says that the corporation would stand vested in me free of all encumbrances. And in terms of section 5 and section 6, my lord, no order would be enforceable against me. My humble submission would be, your lordship would be pleased to, my lord, accept the submission and modify this order to say that opposite party number 4, 5 and 6 discharge this liability, my lord, and no prejudice is caused to the workman. My endeavor is that the workman should get the money. But, my lord, in terms of law, and, my lord, I would not come before if this was a one-off case, my lord, as your lordship remembers that employment case, my lord, one-off case, we accepted your lordship's, my lord, suggestion, my lord, and have given him the employment. Here, my lord, is a case which will open up the floodgates, and the order of the Honorable Division Bench is in the teeth of the statute, my lord. Therefore, all I seek is modification directing 4 and 5 to discharge the amount, or the state should discharge the amount. And that was, my lord, that is also there in 2 orders of this Honorable Court. In this record, my lord, Honorable Justice Jaswant Singh's order, lordship will see, my lord. That is, my lord, order dated 11/11/22. Paragraph number 3, my lord. Paragraph number 3 reads, Mr. L. Samantra, learned additional government advocate, appearing for the opposite party number 1 and 6, and Ms. So-and-so Patnaik, learned counsel appearing for OP number 4, are directed to seek instructions regarding the payment of compensation in terms of order dated 37. And your lordship will also see, my lord, this very proceeding, another order at page 39 of the compilation, wherein in this very proceeding, out of which this review arises, my lord, a prior division bench had also instructed the state at page 41. Learned counsel for the state is directed to take instructions with regard to issue of necessary direction by the state government for payment of the compensation dues of the workmen who were casual employees under the OACB TTPS. And the instructions are still awaited from the government, my lord. Once they take the instructions, the amount can be paid, and your lordship would be pleased to modify the order to that extent, my lord, in terms of section 3, 4, and 5 of the TTPS Act. This is my most respectful submission, my lord.
All right.
In, my lord, one additional part, my lord, lordship will see, my lord, in the order sheet, my lord, a question framed by a prior division bench on 411, my lord, regarding Article 251, my lord. Well, my humble submission would be Article 251 in its scope is limited to, my lord, 249 and 250. Lordship takes Article 251 for a moment. If required, my lord, I'll address your lordships on this.
Not necessary.
There's no conflict of law, my lord. Here, this is an exercise of power by the state legislature under the concurrent list. And my lord, there is an overriding provision. Presidential assent is already there. My humble submission is once this, your lordship is pleased to modify this order in terms of the TTPS Act, the workman can get the compensation.
All right. No grounds made out for review. The review petitions.
My lord, may I then only pray, my lord, your lordship grants me the liberty and says that this will not be treated as a precedent. My lord, it will open up the floodgates otherwise.
It's all right.
My lord, it will open up the floodgates. Let it not be treated as a precedent.
It's all right.
My lord, your lordship will kindly consider, my lord, and your lordship gives me the opportunity to make an attempt to recover it from the state, my lord. Otherwise, this opens up a floodgate of litigation.
All right. All right. Thank you.
Supplementary.
May I pray the part, my lord, of not to be treated as a precedent, my lord. Lordship will kindly consider, my lord.
All right. All right. Yes.
Please, lordship will kindly incorporate that part, my lord.
Thank you. Thank you.
Please.
My
Number
number
4.
number 4, my name may be recorded, my lord.
All right. All right.
Item number 4.
As item number 4, as the last two orders, my lords, it relates to another matter, my lords. It's CR. My lords takes the last order, my lords.
Ah,
is
it's
18.
obviously wrong.
Yes, my lords. My lords, but from my noting, my lords, the next date is 30th of January 2023, my lords.
You say the 18th October order is obviously a mistake as it refers to an IA in a criminal appeal, which has nothing to do with the case on hand. It is clarified that the said order should simply read list on 30th January
30th of January.
2023. All right. The correction be carried out. All right.
Grateful.
Lord, I am for the petition.
All right.
Item number 5.
May I please, your lords? It is a covered decision of my lords.
My lord, the matter is appealable and sufficient
So,
opportunity is
appealable?
given to the petitioner
lord,
for
The
production of notice.
notice, I am only
Lord,
saying,
Only and counter page 5 with regard to payment that in response to the said notice, the Vidya Bharati Education Trust submitted its reply on 24/2 that the operative part of the reply with regard to the payment of 1 crore unsecured loan and donation of 70 lakhs respective to Tarani Education Trust Vidya Mandir volunteer during the session. In this regard, the SIC submit that there is no such transaction with Tarani Education Trust Vidya Mandir during this is only 1 crore 70 lakhs has been added, my lord.
my lord,
So-
my humble submission is that notice
Met with-
148 was
met with-
issued by the department. It is not an actual notice. Can have a glance in their counter page A/2, annexure A. What they have mentioned, my lord, the signing the notice on dated 27th March 2021, notice issued on dated 25 March 2021, which have avowed in my writ petition that notice has not been signed. After being issued the notice from this court, they manifest the document and say that it is the 148 notice. Now, how it is signed on 27th, if issued 25th? So you have manifested that, then you have to patch up this thing, then now say that you go for appeal. For what?
It's digitally signed, sir. It is
Digitally
digitally signed on 27th.
I mean, the upper portion, my lord, issued 25th March.
Correct, but signed on 27th.
Sir, how? We
Why
signed on 27th.
Yes.
Now it issued on 25th, prior to 3 days.
No, an earlier notice being signed later is not a surprise, sir.
My lord, 25th.
Something signed earlier and issued later, that may be another issue.
in-
Whether
my lord,
it's
that-
possible that it was printed out on 25th, but signed on 27th.
Well, the other part is that natural justice has been completely violated in this case, my lord. Why 144B7 they have not implemented? Draft assessment order is not there. Prior to completion of the assessment, that is deal by my
But
lord.
this is prior to 1st April. So how will that 144B apply?
My lord, they have passed the order in the NFS scheme, my lord. Their order itself shows that they have issued the assessment order on the NFS scheme. They adopted everything on the NFS scheme. Yeah,
Where
if
do
hadn't been-
you get this? Where is the assessment order?
that assessment order at Annex
Annexure 9.
3. Annexure 9, they will sign that NFSC.
No, but that's okay. The
they,
question of 144B arises if it's after 1/4/2021, not before.
my lord, it is NFSC. they
Anyway,
have
this is an
found-
appealable order. Assessment order is an appealable order.
And prior to this, my lord, I have to only converse you one point. Let us, my lord, have a glance to page 48.
Yes,
In page 48, in the last paragraph, page 4, it
Yes.
is mentioned that on last 4 line. On the fixed date on 21st March 2022, the assessee submitted that we are in a process of collection information from BB Trust for the document called for. Simultaneously, notice 133(6) of Income Tax Act has been issued to Vidya Bharati Education Trust. On 17/3/2022, two notices has been issued to me and to that Vidya Bharati Education Trust. After getting the reply on 24th March 2002, they have never intimated what they have got it, and they pass out according to their confirmation.
all right.
Is it fair?
You want to, anyway, you say the challenge in the present writ petition is to a notice under section 148 of the Income Tax Act 1961 and the consequential assessment order dated 31st March 2022 for the assessment year 2016-17 paragraph. The said assessment order is obviously an appealable one. Full stop. Consequently, the court is not inclined to interfere at this stage with the said assessment order, leaving it open to the appellant, to the petitioner to challenge it in an appropriate proceedings by way of a statutory appeal. Paragraph, if such appeal is filed not later than 1st March 2023, accompanied by an application for continuation of delay explaining the delay on account of the pendency of the present petition, will be considered by the appellate authority in accordance with law. Court clarifies it is not expressed any view in the matter.
My lord, prior to this, I have annexed C, I have enclosed in my written note submission, where the Supreme Court has clearly dealt that matter can be decided in a writ jurisdiction. My lord.
Yes. All right. Most of the above terms. The interim order is vacated.
Supplementary list for orders, item number 1.
May I please, ma'am? Well, I2 your lordship has directed by order dated 1410 in appointing Mr. Saroj Kumar Das, an advocate of the bar as a arbitrator. But actually, he was the lawyer for the BSNL.
I see.
That's why you have suggesting that there are similar matters are conflicting between both the parties by the one of the arbitrator who is in the arbitration center. We are suggesting his name. It's up to his my own friends.
What's his name?
Consent. He's Sansar Kumar Patnaik, ma'am.
He's a technical person. My lords, may I submit something? My lords, on the last hearing, we have already submitted a no objection for Mr. Saroj Das to proceed with the arbitration. We have no objections about him being a counsel of BSNL. Therefore,
But
my
the
lords,
party,
we have.
well, BSNL is he is the counsel for the BSNL.
He was the counsel for BSNL. That was.
He has no objection. What is your
We
problem?
have given a no
But
objection. already.
BSNL is saying that since he was a lawyer and you are utilizing his services, and therefore he may not.
And, my lords, in the arbitration, what has happened, the evidence is already over. Now only arguments.
Then
are
that is
left.
different.
Oh, I see.
Evidence,
Why are you coming at this stage then? You should have come right in the beginning.
because my lords.
Because I have, when my learned friend has suggested, I have no objection because
No,
he,
evidence is already over. So we are waiting for all evidence to be over to be raising this objection. That's very strange.
regarding closure of evidence, I have no information.
No,
madam.
no,
If
he's
madam is saying that referring that
If
submission,
the counsel for the petitioner
madam.
says that the petitioner has no objection to Mr. Saroj Das being the arbitrator, notwithstanding that he may have been in the past a counsel for BSNL in some other matters. Full stop. He points out that the evidence is already over and it's only the stage of final arguments. Full stop. In view of the above statement, the court does not consider it necessary to modify the order already passed on 14/10/2022.
My lords, one more request. My lords have directed that files be provided to him. They are not providing the files to the learned arbitrator. That is.
That is not part of this. This is his application. All right. The application is
My
dismissed.
lords had passed the order, therefore I'm saying so.
No, not simply like this on an oral submission, sir.
And my lords, item 3 is also connected with this one.
Same, madam.
All right.
Same.
Item 3 also dismissed.
Item number 2.
May please, your lordship. Lordship, this is a matter for extension of time, your lordship. Lordship, I have
No
submitted
objection.
already.
I said, for the reason stated, the application is allowed. The time for rendering the award. This is 29 A's, right?
Yes, your lordship.
Is extended by 6 months from today.
Lordship, I fix a date, specific date, your lordship.
6 months from today, you calculate, sir. Don't leave it to me. I suppose you can calculate.
Yes.
All right.
Item number 4, oblige, your lordship.
Lordship, item number 4, Lordship, I am in virtual mode, Lordship. I have some personal inconvenience. I'll remove the defect in the meantime, your Lordship, may call this matter
All right.
next week.
All right. List on 3rd February. No, 10th February. The defects be removed in the meanwhile.
Item number
Your
5.
Lordship, please.
Item number 5.
Well, I am for the petitioner. Here in this case, I have filed this case for appointing arbitrator here in Orissa. As per the agreement, they are saying that since stipulates there is a clause in the agreement that the place of appointment of arbitrator should be at Calcutta, then it should be referred there.
So you can withdraw and go there, sir. That's the law.
Here, the cause
Yes.
of action arises here in Orissa.
Maybe, but the parties
The-
have agreed on the venue. So
My lord, this type of agreement, my lord, this clause is void, my lord, to the
Why?
extent,
why?
reason being, my lord, if your lordship may kindly see section 57 of Contract Act.
All right. This is not opposed to public policy, sir. Calcutta is just some 200 kilometers away.
Well, here,
Ah.
convenience of the parties must be seen, my lord. Here at Sambalpur, agreement was executed.
Parties have with open eyes signed an agreement. They've agreed that Calcutta will be the venue. So what's your problem?
Your lordship may kindly.
And Calcutta is not some back of beyond, sir. From Orissa, what is it? If you take a car and go to Calcutta in 6 hours, you'll be there. Today, the road is also very nice nowadays.
My lord, your lordship may kindly see for a moment, my lord, the
Yes.
agreement clause itself.
Yes.
I am from the opposite party, my lord.
All right. All right.
My lord, as at page 25
Yes.
of the agreement,
Yes.
clause 9, clause 9.10.
Yes.
Jurisdiction governing under law.
Right.
The agreement is subject to exclusive jurisdiction of the appropriate courts, tribunals, judicial and or quasi-judicial forum at Kolkata. Well, here, no clause is mentioned whether the courts of Orissa has no jurisdiction at all. No other courts, not at Orissa, has not been mentioned. Well, this exclusive term, my lord, will not bar to file a case before the jurisdiction of this honorable court or in Orissa, my lord. And as per section 57 of the Contract Act, if, my lord, a portion of agreement is void and remaining portion is correct, my lord, the remaining portion is to be held as correct, but so far as other portion is, my lord, the wrong portion, that is to be avoided. So, my lord, when the agreement itself is void, well, that cannot be enforced under section 2 of the Contract Act. So this is how, my lord, considering the subject here, that the agreement has been executed at Sambalpur, transactions has been made at Bhubaneswar. So, my lord, for the convenience of the parties, here arbitrator should have been appointed. But here at Calcutta, I have to go such a long place. I am ready to deposit.
Calcutta is long place. Just turn around. Show me one lawyer who will agree with you that Calcutta is a very long distance from here.
Well, I am ready for one-time settlement, my lord. Whatever default amount is.
If you want to
I
settle,
am
nobody
ready to
will
pay.
prevent you from settling, sir. If you want to settle.
Well, that can be settled here. I am ready to pay. By this process, my lord, I have.
Now, if you make payment to them, they will not go into the arbitration. They'll simply tell the arbitrator, we have received payment. Well, no need for arbitration.
My lord, that can be resolved here, my lord. If I pray my lord and senior friend that he may take instructions so that that can be resolved before.
What is the amount due?
My lord, I say, my lord, 11 lakhs some odd, but they are.
Not some odd. What is the amount due from their point of view?
That is disputed, my lord, that he is disputing that he also participated in the arbitration proceeding in Kolkata.
Oh, I see.
But
It's already happening.
Yes.
It's already going on.
What difficulty I am facing
going
there,
on.
they are not providing me the agreement paper.
Yes,
The claim statement, nothing else, my lord. Even in spite of the direction by the learned arbitrator, they are not providing me, they're harassing me. By this process, my lord, how can I contest there?
All right.
Brahmani River pellet is very much clear and your lordship judgment is there in our case.
Right.
My lord, that judgment is not applicable, subject to your lordship's consideration to my case, my lord. My
All
case is something different.
All right.
Because here the agreement was executed at Maharashtra
Mhm.
and
It is at Kolkata, not Maharashtra, Kolkata.
Kolkata, sorry,
Yeah.
Kolkata. But in Maharashtra, application was filed. So,
No, it is in Kolkata, not Maharashtra.
I think he's confusing between the case, the other case I
Yes.
decided and this
Your
case.
lordship.
All right.
Your lordship.
He has a right to be confused, sir. We'll leave
Yes,
him with
yes.
that. Ah,
Okay.
your lordship may kindly allow me to read this judgment.
no problem, sir. Read whatever.
The brief facts which led to filing of this appeal are agenda. The appellant enter into an agreement with the respondent for sale of 40,000 wet metric ton of iron ore pellets on FOB terms, and payment was done to be
What are
made
you
by
reading, sir?
letter
Miss,
page 619.
of which document, sir?
My lord, the
Do I
judgment,
have the document, sir?
the judgment by London senior right now submit.
No, do I have it, sir?
No, I'm sorry.
So this is new style of practice. Don't give the judge also a copy. Start reading.
I'm sorry. Next week.
No. This is another tactic for adjournment.
No,
Certainly not. I'll suffer it. You read it. You read it. No problem.
no, I'm sorry. my lord.
No, you don't have to be sorry, sir. That is your understanding of how practice is done.
No, my
in
lord,
courts.
I will not.
It's
do
all right, it's all
henceforth,
right.
my lord.
It's all right, sir. Can carry on reading. I don't want you to say I was prevented from citing.
No,
a
my lord,
judgment.
I'm sorry, my lord.
Ah.
By this process.
Kindly go ahead. Kindly go ahead.
My lord, next week.
No. We're not certainly not adjourning it, sir. Whatever else you want to say, you please say.
Well, that judgment, my lord, I will provide on Monday.
No, you read it, sir. All yours. I will be extra attentive. No problem. Read it.
The appellant entered into an agreement with the respondent for sale of 40,000 wet metric ton of iron ore pellets on FOB terms, and payment was to be made by the letter of credit in Bhubaneswar. The loading port was Dhamra Port, Bhadrak, Odisha, and destination was Chennai ports, Tamil Nadu. Dispute arose between the parties regarding the price and payment terms, and the appellant did not deliver the goods to the respondent. The respondent claimed for damages, alleging that it had to procure iron ore pellets from other sources at higher rates. The appellant denied any liability to pay damages on the ground that the contract was later modified and that the respondent breached the material terms of the contract, and this led to the dispute between the parties. Clause 18 of the agreement between the parties contain an arbitration clause which reads as under: arbitration shall be under Indian Arbitration and Conciliation Law 1996, and the venue of arbitration shall be Bhubaneswar. The respondent on 7/10/2016 invoked arbitration clause. The appellant did not agree for the appointment of the arbitrator. Hence, the respondent filed a petition under section 11(6) of the Arbitration and Conciliation Act before the Madras High Court for appointment of sole arbitrator. The appellant contested the petition challenging the jurisdiction of the Madras High Court on the ground that the parties have agreed that seat of arbitration be Bhubaneswar, and therefore only the Orissa High Court has exclusive jurisdiction to appoint the arbitrator. The Madras High Court, while impugned order, appointed a former judge of the Madras High Court as the sole arbitrator by holding that mere designation of seat by parties does not oust the jurisdiction of other courts other than at the seat of arbitration. The High Court held that in absence of any express clause excluding jurisdiction of other courts, both the Madras High Court and Orissa High Court will have jurisdiction over the arbitration proceeding. Challenging the impugned order, the appellant has preferred this appeal. The learned counsel for the appellant submitted that when the parties have agreed for a place or venue of arbitration, it gets the status of seat, which is the judicial seat, and therefore only the Orissa High Court will have the jurisdiction under the Act. The learned counsel submitted that the Madras High Court.
You want to read the operative portion, sir? You want to read the operative portion of the judgment?
No. Since my lord, this judgment is not, I have not supplied before your lordship.
No. Just read the operative portion, I'm saying. Instead of reading every full stop comma, just come to the operative portion.
Where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. In the present case, the parties have agreed that the venue or arbitration shall be at Bhubaneswar. Considering the agreement of the parties.
According to you, this judgment helps you.
No, my lord, this will not help.
After 10 minutes, you realize
My lord, here I am.
you're citing a judgment which does not help you.
My lord, only
All
here.
right. All right. Anything else, sir? All right. You see, the agreement in the present case clearly specifies that you see, clause 9.10 of the agreement clearly specifies that open quotation, this agreement is subject to the exclusive jurisdiction of the appropriate courts, oblique tribunals, oblique judicial and oblique or judicial quasi-judicial forum at Calcutta, unquote. So the clause 9.11, the agreement, which is titled Single Courts Dispute Resolution Arbitration, unquote, clearly specifies open quotation, the proceedings shall be held at Kolkata, unquote. In that view of the matter, this court holds that it lacks the territorial jurisdiction to entertain the present application. So it will be open to the petitioner to seek appropriate remedies before the concerned court in accordance with law. The petition is disposed of.
And the opposite party may be directed to supply the claim statement and all other relevant documents so that I will.
That's not part of this applications. Right.
Item number 6.
Number 6, you're also filing the counter today. Let's have a copy. I've already.
Why did you use the other mic, sir? Yes. What's your stand, sir?
Section 12(5). The petition, it was before the amendment that is came in 2015. That's why 12(5) is applicable because we have not.
No, agreement may be. When did the cause of action arise? When was the claim made?
2017.
When did they issue a notice raising the claim?
2019, your lordship.
So that's post amendment, sir. That's post amendment.
My lord.
Ah.
And your lordship, one more thing in this case, it is only really release of security deposit, but because of a pendency of vigilance case, the security deposit could not have been released. That is subject matter of the dispute. The final bill has been received because the security deposit is to be kept in a security account.
If you have instructions to pay him the security deposit, I'll record it. When will you pay it?
Because of the pendency of vigilance case, only security deposit has not been released.
No, now you're prepared to release.
No, it has not been released.
Then we'll have to refer it to arbitration. If you're prepared to make a statement that you will release the security deposit, then there's no need for arbitration.
Sorry, I cannot make this statement.
That's all right. the counter affidavit filed by the railways has been perused. It is sought to be contended that since the agreement was entered into prior to 2015 amendment to the Arbitration Conciliation Act, Section 12(5) of the Act as amended would not apply. Full stop. This is based on a misconception, since the cause of action as far as the petitioner's claims are concerned arose only thereafter. Full stop. The notice to the railways in this regard was sent by the petitioner on
22nd 11/2019.
22nd November 2019. Full stop. Consequently, the railways cannot insist that the arbitrator appointed, named by it in the agreement will have to be the sole arbitrator. Paragraph. What's the value of the claim?
60 lakhs, my lord. 60 lakhs or more.
The objections of the railways to the appointment of the request for appointment of an arbitrator is accordingly rejected. Full stop. The court appoints.
May I suggest? Mr.
Mr. Gautam Mishra, senior advocate as sole arbitrator, considering the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center.
Grateful, man. Odisha arbitration.
Correct.
High Court. Grateful, man.
Item number 7.
May I please?
Yes.
Counter affidavit has been filed. Here, my lords, the arbitration clause is at page 17, my lords.
We have filed the counter.
What's your stance, sir?
The objection taken is in paragraph
8, Lord.
para 8. They say that the final bill was paid in 2013. And thereafter, I have raised a claim under 10CA and 10CC, which are not maintainable.
No, but escalation bill, they admit you raised it in 19/4/2013.
Yes, my lords. They admit that, and they have, if your lordship sees one document, that is at page 52, my lords. 51, my lords. Page 51. Please refer to the cited level. We raise certain claims under clause so and so, and others in construction of the above work, and requested treat your letter as arbitration notice. In this connection, it is requested under clause 25(1) of the GCC to.
And we will leave this for the arbitrator to decide.
Yes, my lord.
Let him decide.
But my lord, he is a case who worked in complaint 2011. Whole and final settlement is made in 2013.
I know, but let the arbitrator examine all that, sir.
But
the arbitrator can examine.
What my preliminary objection for my lord is that
yes,
this only because of this FD was with us for 10 years, because this is a clause basing on which they can invoke the cause of action after 3 years. That too, it is 2011 and now 2023.
Can you see the letter?
This is this because only point they have that because FD which you thought in 2020.
No, 20 July 22, you're calling him again for negotiation, for discussion. Let the arbitrator decide whether it's time barred. We won't fire. You say the counter affidavit of the opposite party CPWD has been perused. To stop, one of the objections raised is that the work was completed on 25th August 2011 and final bill was paid to the petitioner on 30th March 2013. Stop. It is, of course, it is, however, admitted that the petitioner then raised an escalation bill on 19th April 2013. Full stop. Paragraph. Mr. Gautam Mukherjee, learned senior counsel appearing for the petitioner, refers to a letter written by the CPWD to the petitioner on 20th July 2022, calling him for a discussion about his claims along with the details of calculations and relevant materials, open quotation, for taking further necessary action, full stop, unquote. Paragraph. This court is of the view that the issue whether the petitioner is stopped from raising any further claims and whether such further claims are barred by limitation is an issue that can be examined by the arbitrator. Full stop. The court accordingly appoints, what's the
The
60 lakhs?
65 lakh.
MD Pradhan one discharge empanel Lord Singh also
Justice Naidu or a senior advocate?
That senior advocate is enough, sir.
Just Mr. DP Nanda, your lordship.
Mr. DP Nanda, senior advocate, as sole arbitrator to adjudicate the claims between the parties, including the claims and counterclaims. The arbitration will take place in the wages of the arbitration center.
Item number 8.
As item 8, my lords, we received an instruction that we'll be appointing the arbitrator. If my lords may give me 2 weeks' time, I should come back with the name of that.
You'll be appointing meaning?
Meaning under the act, my lords. Under the act, we have already, my lords, taken steps for because it's with the government, we have to take the
So what? Where do you get the right to appoint? It's all hit by 12.5.
Yes, that's there.
You said, having heard learned counsel of the parties and having examined the agreement in question, the court appoints. What's the value for your claim, sir?
199 crore.
199 crores?
Yes.
Oh. You can start saying. Justice Deepak Mishra.
Three member. I'll have to.
Do you want to have a 3-member arbitration? What's the clause say?
Yes, ma'am. The clause is 26(3), the agreement that disputes were to be resolved amicably, and if the same fails, the disputes are to be resolved through arbitration to be adjudicated by a tribunal comprising of 3 arbitrators.
Comprising 3 members.
So therefore, it's our nominee. We'll have to select our nominee.
All right. You see, under the arbitration clause, a 3-member arbitration tribunal is contemplated. Both parties will give the names of the respective nominees.
Yes.
To each other within a period of 10 days from today. And the said 2 nominees will in turn appoint the 3rd member within a further period of 10 days thereafter. Full stop. Paragraph, if there's a failure for the tribunal to be constituted within a period of 2 months from today, it will be open to the petitioner to revive this application. The petition is disposed.
Specialist. Specialist fresh admission item number 1.
Please, Lord. Lord, I have challenged my Lord Annexure 5, page 36, my Lord. Wherein, my Lord, the Learned Session Judge, my Lord, was pleased to transfer on a ST case, my Lord, from the court of the special track court from Assistant Session Judge to the Additional Session Judge, my Lord. Here, my Lord, the case was registered and charged under section 376(2)(a), III, along with allied offense, and 376(2)(n) is the major offense, my Lord. And my Lord, after commitment, my Lord, the Learned Session Judge, as per section 194 of CRPC, my Lord, was pleased to transfer the case to the Assistant Session Judge, my Lord, special track court for my Lord, taking of the trial. And charge was framed, my Lord, it's a part case. And my Lord, some of the witnesses, 4 witnesses have been examined. My Lord, some of the witnesses, my Lord, they, my Lord, do not support the prosecution case. For that reason, my Lord, alleging, my Lord, some vague allegation against the public prosecutor, my Lord, the informant is, my Lord, Inspector of Police, my Lord. My Lord, she has filed an application before the Court of Learned Session Judge under section 4(8) of CRPC, my Lord, trying to transfer the case. My Lord, the Learned Session Judge, my Lord, after applying judicial mind, my Lord, it was transferred to the court of, my Lord, special court from Assistant Session Judge. My Lord, observed that, my lord, the punishment prescribed under section 376 to N of Indian Penal Code is not less than 10 years. But, my lord, it extends to imprisonment for life. And, my lord, more punishment is required, my lord. And the Lord Assistant Session Judge has no power under section 28(3) of CRPC to inflict, my lord, maximum punishment. He was pleased to, my lord, transfer the case, withdraw the case and transfer to the Court of Additional Sessions, which is prejudged, my lord. Before, my lord, termination of the trial, the Lord Session Judge, my lord, has expressed his mind, my lord, this case.
Hardly anything. Anyway, the person trying is not the sessions judge.
No, my lord, it's a Sessions Court, my lord.
Sessions court is different. The
My lord.
judge who passed this order is not the judge trying the case.
My lord, Assistant Sessions Judge is empowered, my lord, to try the.
You're apprehensive that because he has expressed his mind, it will influence the outcome in the trial, correct?
My lord.
But the person who passed this order is not the person who is trying the case. It's another judge who's trying the case.
My lord, like, my lord, section 325, my lord, if during, my lord, before pronouncing judgment, if the Lord Trial Court will be found, my lord, more punishment is required, my lord, he can.
That's a different court which is trying, sir. It is clarified that the observations made in the impugned order dated 9th May 2017 of the Sessions Judge Baleshwar in criminal miss case number 12 of 2017 would not affect the final outcome in the trial. So, in other words, the trial judge will apply his independent mind to the evidence led by the parties and pronounce judgment in accordance with law. In that view of the matter, the impugned order calls for no interference. The petition is dismissed in the above terms. The interim order is vacated. Right.
Specialist item number 2.
Lordship, the item 2, the matter has become infructuous.
Dismissed as infructuous.
Specialist item 3.
None appears dismissed.
Specialist item number 4.
None appears dismissed.
Specialist item 5.
May I please your lordship? Your lordship, appearing on behalf of my senior learned counsel, PC Jana. Your lordship, this is an application for challenging the order passed by the learned JMFC Salepur, your lordship. Your lordship, the learned JMFC has passed an order against the petitioner under Domestic Violence Act, Section 12, along with Section 23. Your lordship, in this case, there is no specific proof of marriage with the respondent, and there is no specific marital relationship. Then how the domestic violence can arise and Domestic Violence Act can be put against the petitioner and
examined, sir, by the trial court, not at this stage.
Well, let's see.
That will require evidence to be led, sir. Let the trial court.
No specific evidence has been there, and the respondent also filed in family court, and family court has rejected his maintenance. As no specific marriage evidence is there, and in lordship, JMFC has also passed that 5,000 rupees would be given by the petitioner to the respondent as maintenance. But then lordship, that is that's an illegal, as there is no income of the petitioner has been there, and without any income, then how the petitioner can give money as it is illegal and arbitrary, lordship.
All right. Having heard learned counsel of the parties, the court is not inclined to interfere with the impugned order dated 8 June 2016 passed by the JMFC Salepur in this case number 73 of 2014. In any event, the order is of an interlocutory nature without finally deciding the merits of the case. We'll stop, leaving it open to the petitioner as well as the respondent to urge their respective contentions on merits at the appropriate stage in the trial court. This court declines to interfere at this stage and dismisses the petition. The interim order is vacated.
Highly obliged.
Item number 6.
None appears dismissed.
Item number 7.
In this case, there may be a date check may be necessary. Still, I'm submitting, the impugned is the complaint petition, which has already been adjudicated prior to that, and the findings are quoted. I have I'm instructed that under the RTI Act that he has obtained it. I'll be filing the affidavit a day or two. Your lordship may call it any day next week, my lord.
For what, sir? Nothing.
Your lordship may kindly see then I have quoted the order, that finding.
You withdraw the petition. If it's in your favor, you withdraw it.
No, your lordship may kindly come to page 3.
No.
Page 3 at the bottom, para 5, second para. Para 5 is that while such was the position, the opposite party number 2 lodged another complaint before the Commissioner of Police Bhubaneswar on 21/2015, which was treated as a grievance petition, and the petitioner was called upon to attend the inquiry. In response to the same, the petitioner participated in the inquiry and submitted the documents, including the copy of the compromise arrived at between the parties in the office of IIC Chandaka Police Station. The said complaint opposite party number 2 before the Commissioner of Police was examined, and the following finding was recorded. This finding is important, my lord. With reference to the subject cited above, this is to inform that on receipt of the petition filed by the petitioner Prashant Kumar Harichandan, I inquired into the matter locally in presence of both the parties and local witnesses. During inquiry, it became known that on 16/12/2002, the petitioner Prashant Kumar Harichandan had executed an agreement with Rajesh Kumar Das, so and so, who is working as a contractor at Trident Galaxy Properties Limited, and as per the agreement, a lift machine of 12 HP capacity and the petitioner was utilized in the construction work of so and so in terms of cash of rupees per month under the control of Rajesh Kumar Das. As the construction work was over in the month of 2014, there was no necessity of that machine, and Rajesh Kumar Das requested the petitioner to take his machine along with so and so, so and so. Thereafter, you lordship may skip it at the bottom, my lord, the para. That is important in relation to the complaint. I'll take your lordship to the complaint. Surprisingly, at present, this is the finding of the police officer after inquiry. Surprising at present, the petitioner is alleging that he had handed over another mixer machine to Rajesh Das, though it was not told by the petitioner nor reflected in the agreement made at Chandaka Police Station on 7/1/2015, as the petitioner had been to PS with his advocate and friends and subsided the matter locally to a mutual agreement. The allegations such as threat received on the way to PS and dues of second mixer machine, etc., was proved to be false and fabricated. This is the finding after the inquiry, my lord. Now the complaint petition, your lordship may kindly see how the complaint has been couched. At page, your lordship may kindly come to page, it starts at page 17.
Yes.
The 19, page 19, your lordship, para F, that in spite several demands, the complainant, the accused person has not paid the entire amount and forcibly kept the machine in the possession and using it for his own benefit. The complainant also lodged complaint before the Commissioner of Police, but no result come out. The finding I read out, my lord, the Commissioner of Police. Here the complaint is no result came out. Complaint was filed. Next para, my lord. That it is submitted that the above said 2 machines have been entered with the accused persons by virtue of a legal contract. Now the contract is Annexure 3, my lord. The mixer machine was not there. Contract is Annexure 3. Now the report has 156.3 on the complaint. 156.3, the police the local police, it sent to the local police. Now the report of the local police is a report that is important. Impugned, my lord. Your lordship at page 28.
Yes.
As the offenses under section so and so, liable within 7 years below as guideline of the apex court, I served the notice under section 41 so and so, as there is prima facie evidence is well established that the accused person, normally Rajesh Kumar Das, son of so and so, 20, is him to stand trial under the common contract law. Well, it was inquired into, local evidence, everything was settled there. And now again on the very same complaint, very same fact, the complaint petition had been filed by then, and now it has gone to 156.3 and this report has come.
Yes.
He is to face the trial.
Yes.
It has reached to final. This the finding of the inquiry officer, I have quoted, my lord. That I have got the copy by way of RPI. That is what I wanted to produce before your lordship.
All right. You say permitting the petitioner to raise all pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of.
That is to be adjudicated first, my lord, not
Yes.
in course of.
All right.
Item number 8.
No instruction, my lord.
No
Kindly-
instructions dismissed.
kindly
All right.
permitted.
Interim order is vacated.
Item number 9.
None appeals dismissed. Interim order vacated.
Item number 10.
Item 10, my lord, permitted to withdraw.
This
And
is
liberty to
withdraw.
state all the points before the trial.
Yeah, permitting the petitioner to raise all pleas at the appropriate stage.
Obliged, Lord.
Specialist item 11.
No instruction about the matter.
No instructions dismissed. All right.
Item 12.
Item 12, also the matter has become infructuous.
Infructuous dismissed.
Item number 13.
In my lord, petitioner had no knowledge in the affair and the charge sheet, the allegation of knowingly carrying the contraband article in his transportation in his vehicle. The section 25 is the bar, my lord, the for knowing convenience knowingly. And then section 35 presumption will come. My lord, I have a decision of the, well, our own High Court. I have a copy. Burden lies on the prosecution to establish that owner of the vehicle knowingly permitted the vehicle to be used for permission of an offence punishable under the Act. My lord, can skip over the one page, my lord. Paragraph 4, relevant persons. Section 25 of the Act provides the inter whoever being the owner of the conveyance knowingly permit it to be used for commission by any other offence of an offence under the any provision of shall be punishable with the sentence mentioned. The linchpin of the offence under the section 26 thus lies knowingly permitting use of the vehicle for commission of an offence under the Act. He doubt under the section 35 of the Act, the court shall presume culpable mental state of the accused in any prosecution for an offence under this Act, under the Act. Then your lordship kindly skip middle portion. But in the case of under section 25 of the Act, it is for the prosecutor to establish the owner knowingly permitted the vehicle to be used for commission of an offence under the Act. Then your lordship skip over the next page, man. Upper portion, man. The upper portion is cannot be pressed into service by prosecution in Raghunath Singh versus State of Madhya Pradesh, 1967, Maharashtra Law Journal 570. The Supreme Court held that the words knowing or knowingly are used to indicate that the knowledge must be proved either by positive evidence or circumstantially before mens rea can be established. The word knowing and knowingly are obviously more forceful than words are reason to believe because they insist a greater degree of certitude in the mind of the person who is said to do the act and knowing. The section, your lordship kindly turn to the page 39 of the seizure memo. Second line, the property seizure, your lordship got it?
Yes.
Page 13. One registration certificate of the involved vehicle bearing number registration in the name of owner Sam Sundar Thakur has been seized. Then your lordship is the page 56, the state 161 statement of the ASI is in Odia, last portion. That I read it in your lordship has the English copy.
That's all right. Read it.
It is in two person in Indigo car registration service at Raulkela, Sam Sundar Thakur in the name of Sam Sundar Thakur. Then your lordship is page 10 of the FR story, kindly see. in middle person, indigo at 11:20 AM as per source information, one white color indigo ECS registration number OD 14G 1908 was coming as per prior information from Nandapur side. Then your lordship skip 2 lines. We have noticed that 2 persons were sitting in the front seat of the vehicle, including the driver and another lady beside him. On the back seat, there was also 2 persons sitting. While stopping the vehicle, all of a sudden, 2 persons, that is the driver of the vehicle and 1 person sitting in the back seat, have managed to flee away from the spot towards the nearby Bossy jungle. We chased them, but they could manage to escape. Then the page 27 of the relevant portion of the chart sheet. Page 27. Page 20 is the chart sheet, page 27 is the relevant portion. At dated 11/8/2010, 30 by letter no 1367, 1368, stating that in the fact SD number, namely Narendra Kumar Singh and Susuma Prasad with 1 white color indigo containing the illegal contraband in presence of the witness, Kupa Sindhu sign. Then your last person arrested the accused person Narendra Kumar Singh and Susuma Prasad, age 31, daughter of the only charge sheet in my name is not there. FIR is in my name, not is that. I am only owner.
All right. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the court declines to interfere. The petition is dismissed.
Item 14.
The interim order is vacated. Right.
Item number 14.
None appears dismissed. Interim order vacated.
Item number 15.
None appears dismissed. Interim order vacated.
Item number 16.
None appears dismissed. Interim order vacated.
Item number 17.
None appears dismissed. Interim order vacated.
Specialist item 18.
Item 18 permitted to withdraw, Your Lordship.
All right. Permitting to raise all pleas. All right.
Item 19.
None appears dismissed.
Item number 20.
20 has become infructuous, madam.
Dismissed as infructuous.
Item number 21.
None appears dismissed.
Item number 22.
Permitted to withdraw, my lord.
Dismissed as withdrawn.
Item number 23.
None appears dismissed. Interim order vacated.
Item number 24.
24, my lord, I have challenged the order of cognizance. Both the accused and the victim are related to as sister-in-law and younger brother-in-law. So case of 376 and 511 is not made out because in her one sister statement, she has categorically stated that we are related to as sister-in-law and brother-in-law. The present petition come and court hold from her backside. So my respective submission would be that no case of 376 or 511 is made out. It is at best a case of 354.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is dismissed.
My lord, one thing more. My lord, one thing more. NBW is pending against the present.
Can't be helped. So 376.
My lord, since attempt, my lord. 511 is there, and both are related and compromise of in between them is going on, my lord. Both are one family, my lord. Lordship, I am permitted to surrender, and my lord.
Item 25.
Memo is taken on record. Dismissed as withdrawn. Interim order vacated.
26.
Same.
Item number 27.
None appears dismissed. Interim order vacated.
Item number 28.
Same order.
Item number 29.
Same order.
Item number 30.
May I please, Your Lordship? May here the order challenging cognizance Usually your lordship objects that it should be at the stage of charge. May I pray, my lord? I'll raise the point at the stage
Correct.
of charge.
Permitting the petitioner to raise all please. All right.
Grateful,
Into
my lord.
order vacated. Right.
Grateful, my lord.
Item 31.
Your lordships, item 31 permitted to, VC lordships, permitted to raise all pleas at the appropriate stage.
All right. Permitting the petitioner. All right.
Item 32.
32 no instruction.
No instructions dismissed. Into order vacated.
Item number 33.
None appears dismissed. Non prosecution. Interim order vacated.
Item number 34.
None appears dismissed. Non prosecution.
Item number 35.
Your lordship, in item 35 on behalf of Mr. Panda, I pray that the matter may be taken up next week, your lordship.
Why, sir?
Your lordship, the file is not traceable.
Then we'll dismiss it. You revive it whenever you find it.
Your lordship may put it next week, your lordship.
Counsel, the petitioner states that the file is missing. Dismiss the non-prosecution with liberty to revive the petition as and when the file is recovered.
My lords, on behalf of the
Interim order is
opposition, I am
vacated.
appearing my appearance may kindly.
All right.
Item 36.
Praise the Lord. Well, the case is on complaint has been filed for on the allegation of violation of Drugs and Cosmetic Act, my lord. There is a clear violation of your lordship kindly turn to page 17. There is a clear violation of section 25(3) of the Drugs and Cosmetic Act, and exactly on the same issue, my lord, has been decided with Honorable Supreme Court. Honorable Supreme Court has passed the proceeding for non-violation of the exactly covers, my lord. Lordship kindly see the page 17, my lord, 17, and judgment of certain. Lordship kindly see on 2287 and Lalit Kumar South. Sir.
Where are you reading, sir?
Page 17, 17.
Right.
Second paragraph.
Yes.
That on date 22/8/7, this is Lalit Kumar Sahu, the then drug inspector, Blanket Range. Blanket has drawn statutory sample of 4 persons into 200 ml of the drug, so and so drug. So manufactured by 3 Big Healthcare Limited at the present petitioner. My lord, the address is there. Then the lordsman kindly see the for Woolander address is there. Then the lordsman kindly turn to the next page once the drug annexed for the purpose of test analysis, and 1 sealed portion of drug 1 into 200 ml of so and so drug was sent to government analyst state testing center Bhubaneswar by form number such and such, memorandum such and such. The purpose of test and for the purpose of test public analysis, that the government analysis of state and research laboratory declared the above mentioned drug as not of the standard quality by form 13 test report and DTR number so and so dated 15/7/8. The sample is not of the standard quality of the. As per your lordship, kindly see will check the section the next parameter that as per the government of Orissa Health and Family Department notification about such and such dated such and such, the undertaking took over the charge of the newly created office of the drug inspector Kebanapur in Sabanpur on 1/10/2009 along with related documents, that the portion of the drug sample as required under section 23(4) Roman 3 of and a copy of the test report in form 13 is required under section 25.
So the SDGM has not passed any order yet.
No, they're taken cognizance. Lordship kindly see the lordship kindly this is the Supreme Court judgment directly on the point for violation.
What has happened here, sir?
Happened, my lord. When they issued so-called notice on section 25(3), within 28 days, I have given reply.
On this complaint, what has happened?
The cognizance has been taken.
Where is the order? Where is the order?
Cognizance order, my lord. Summons has been issued, but the order has not been.
There's no order.
Page 23. At page 23.
What does it say?
Record is put up today for taking cognizance, peruse record, and it is found that cognizance is available on record to proceed against the accused person on section 27D of the Drug and Cosmetic Act 1940. Hence, cognizance of the offence and section so and so is taken.
Only that stage, nothing else is happening.
No, but what I am similar, the Honorable Supreme Court has passed the proceeding only on the ground of the violation of section 25. For a minute, or kindly sit only for a minute. But had it not been there, I would not have placed my lord.
Yes.
The lordship kindly see the judgment, para 15. Sorry, para 16, 1/6.
Yes.
It is therefore evident that appellant had not once
but at least two occasions within 28 days of the receipt of the show cause notice clarified that it intended to adduce evidence to show that the test report of the government analyst was not correct. The judgment cited by the Learned Counsel for the respondent therefore do not apply to the facts of the case, as well they are giving the context in the context where the dealer manufacturer had not expressed a desire to challenge the veracity of the report and drug analysis. Then my lord may kindly turn to para 18, 1-8. Last page of the judgment, my lord.
Yes.
The para starts with we find.
Yes.
We find that the judgment helps the case of the appellant rather than the respondent, because in spite of two communities from the two communications from the appellant that is intended to adduce evidence to controverted fact given in the report of the government analysis, the fourth sample with the magistrate had not been sent for reanalysis. The observation in Ameri pharmaceutical case are also in the to the same effect. We find that opposite interpretation supports the case of the appellant in as much as they have been deprived of right to have the fourth sample tested from the central drug laboratory. It is also clear that
there is nothing like that here, sir.
But
Nobody has refused your request for testing.
The para 19. In this case also this has happened, my lord. We have within exactly the facts are exactly akin, my lord. In this case also we applied for testing to be done by central laboratory. That has not been done, and that is the reason for para 19. I mean, Supreme Court has passed the proceeding. That the Supreme Court has passed. Page 25 for a minute or so, only page 25. I would not have for the 25 of the petition.
Yes.
2008, my lord, I have applied.
Yes.
Kindly see page 25.
Yes.
We are in receipt of your letter number such and such, letter such and such, and noted we have received this letter along with the certificate of analysis number so and so issued by the government analysis drugs testing and research laboratory in Orissa in date 5888. It has been observed from the report of the government analysis that above cited drug is substandard with respect to the content of the fungal so and so so and so. In this regard, we would like to submit as under. The next page, my lord, let's kindly see the page 26, last but one paragraph. So we are not satisfied with the findings of the government analysis, state drug testing and research laboratory Bhubaneswar. We do not accept the result and the test of the government analysis drug number such and such, detail number such and such, and we intend to adduce evidence in contravention of the same. And we request your good self to kindly send the remaining portion of the sample through the honorable court to consent to the director of the Central Drugs Laboratory for retest analysis as per section 25(3) and 25(4) of the testament. We are ready to pay the cost. So because that has not been done in the case of Supreme Court, my lord, Supreme Court had passed the proceeding. And without complying the same, they simply submitted the complaint. 4 years after 2000, there is also limitation also, because in this case offense is up to 2 years. The limitation is up to within 3 years they have to file the complaint. That limitation is also there, is also barred by limitation. But on this ground and another ground, my lord, another Supreme Court also, the Honorable Supreme Court has quashed the proceeding on another ground also in the exactly similar case. Para 19, my lord, will accept from this that very case Supreme Court. Honorable Supreme Court has categorically recorded that and quashed the proceeding. That is the reason why, my lord, I am placing authorized, I would not have placed. They give not the opportunity, and they did it 1 year after the sample taking.
Who's for the other side?
Yes, I'm ready.
Just tell me one thing, all this testing and all happened in 2008.
Yes.
And the complaint is filed in 2017. How come?
That I will find out, because records have not been called for the first time. It will be also. Get all these.
Notice was issued.
Notice was issued here. When was notice issued? 2018.
Because order was 20th of March 2018. There was a direction for obtaining instruction only. I will obtain the instruction if necessary. But all the records I will get, whether it has been sent to the library and what is the cause of delay in lodging the complaint.
All right. You see, Mr. M.K. Mistral and senior counsel refers to the fact that the complaint itself was filed only on When was the complaint filed? 2012.
2012, my lord. It is on, the cognizance was taken in 2012, complaint.
No.
The complaint was filed in
Issued summons in 2017.
2000, issued summons in 2017. Cognizance was taken in 2012 and the complaint has been filed, just. The
See, it's
complaint.
2C number 55, 2012.
Yes.
Yes.
Summons was issued.
Summons was
Points
issued.
out that although the date and time of sampling was 22nd August 2007, the complaint itself was filed only 5 years later in 2012. Full stop. Further, cognizance was purportedly taken much later by the SDJM. No, cognizance was taken on 2nd April 2012. Then what happened for 5 years after that?
I do not know, because someone I got someone.
It appears that summons was issued, however, only 5 years later, on 11th August 2017. Full stop. There appears to be delay at every stage of the proceedings. Full stop. Paragraph. It is further pointed out that despite the petitioners seeking further testing of the sample by a central laboratory, by the central drugs laboratory, that request was not heeded. Reliance is placed on the judgment in Medica Men Biotech Limited versus Rubina Bose, 2008, 7 SEC 196. Paragraph. In the present case, on 22nd March 2018, Counsel for the State was asked to take instructions. Full stop. Today, Mr. Samantra appearing for the state needs more time for that purpose. Full stop. He states that he will ask for the relevant records for the next date. You see, interim order to continue, list before the roster bench on 3rd April. The records of the case will be produced. The records of the case available with the state will be produced before the court on the next date.
Item 37.
Deeply obliged.
May I please note?
My sole prayer, my lord. Released non big earlier, 493.
The case is turned to 376 and POXO is there, my lord. Only my prayer that I may surrender and go on bail, that will kindly give the liberty, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petitions disposed of, interim orders vacated.
Item number 38.
None appears dismissed.
39.
No instruction.
No instructions dismissed.
Item 40. Grant me liberty, my lord, I will raise that.
All right, permitting the petition. Interim orders vacated.
Item 41.
None appears dismissed.
My lord, item 40, my lord. May it please your lord, appearing on behalf of Mr. B.B. Rautrai, my lord, no instruction.
He is appearing in
Item 41.
41, no instruction, my lord.
No instructions dismissed. Interim order vacated.
Item 42.
None appears dismissed.
I appear for the opposite party.
All right.
Item number 43.
None appears dismissed.
Item number 44.
Memo taken on record. Dismisses withdrawn, interim order vacated.
Item 45.
None appears dismissed, interim order vacated.
Both the cases.
Yes.
Item 46.
Memo taken on record. Dismisses withdrawn.
Item number 47.
My lord, no instruction.
No instructions dismissed.
Item 48.
None appears dismissed.
Item number 49.
Same order.
Item number 50.
Same order.
Item 51.
Same order.
Item number 52.
Memo taken on record. Dismisses withdrawn.
Item number 53.
None appears dismissed.
Item 54.
Same order.
Item 55.
Same order.
Item number 56.
Same order.
Item number 57.
Same order.
58.
None appears dismissed.
Item 59.
No instruction, my lord. No instructions dismissed.
Item number 60.
None appears dismissed.
Item 61.
None appears dismissed.
Item 62.
Permitted to resolve, but
Permitting the petitioner to resolve please at the appropriate stage. Right.
Item number 63.
None appears dismissed.
Item number 64.
None appears dismissed.
Item number 65.
Lordship, I am appearing for Mr. Debandas.
Yes.
Your Lordship, only prayer is the present case may kindly be withdrawn.
All right. Dismiss is withdrawn. All right.
Item number 66.
66 no instruction, my lord.
No instructions dismissed.
Item number 67.
may it please your lordships, I am appearing on behalf of Mr. Chinmay Mahanti, counsel for the petitioners. My lords, in this case, the petitioners have filed this present application for quashment of the proceeding initiated against them on the ground of amicable settlement intervened by their elders in the villages. But my lords, subsequently, the petitioner have also filed a CRMC number 368 of 2021, which is still pending in this honorable court.
All right. Permitting the petitioner to resolve please at the appropriate stage.
Obliged, lords.
The petition is disposed of.
Item 68.
None appears dismissed.
69.
None appears dismissed.
Item number 70.
My lord, permitted to withdraw.
Dismiss is withdrawn.
Obliged.
Interim order vacated.
71.
21, I may please your lordship. So the order taking cognizance of offence under section 294, 323, 506, 34 and section 3 of SC/ST Act is under challenge, my lord. The informant, my lord, filed a complaint case. In the complaint case, notice was direction was issued to the police to investigate into the matter under section 156(3), my lord. While the investigation is in progress, the informant, the complainant, filed an affidavit before the concerned magistrate that the matter has been compromised between the parties. The lordship, that is in vernacular, Annex 2 is the affidavit. And on the basis of this affidavit, the lordship may turn to in Annex 3. The lordship, I may be permitted to place. Here the learned magistrate directed the police to produce the record for compromise of the matter. The lordship, I may be permitted to place. The case record is put up today on the strength of an order, an affidavit petition filed by the advocate for complainant and prays in a petition to withdraw the case as the matter is compromised between the two parties. Considering the petition, it reveals that the matter has already been compromised and the concerned IAC is directed to return the original complaint petition put up on 18/2/15 for awaiting the original complaint petition. Despite of this order, my lord, the police did not return the file, ultimately submitted charge sheet, my lord. After submission of charge sheet, my lord, the Learned SDGM has taken cognizance of offence under the section 294. Your lordship, page 25 is the order taking cognizance of offence, has taken cognizance of offence under section 294, 323, 506, 34, reduced section 3 of SC/ST Act. My humble submission, my lord, is since the matter was compromised between the parties and instruction was issued to the concerned investigating officer to return the file as it has been compromised. Subsequently, my lord, the order taking cognizance on the basis of the charge sheet submitted by the police, my lord, is not appropriate. Therefore, my lord, I am also relying upon a decision of the Honorable Supreme Court, my lord, wherein it is held that even after submission of charge sheet, the magistrate has got power under ample power under law, my lord, to para 15, my lord.
Relevant question is, my lord, at para 15 towards the last, my lord. Towards the bottom, para 15, my lord. In the fact and circumstances, it cannot be said that while directing the police to register FIR, the magistrate has committed any illegality. Your lordship got it. As a matter of fact, even after receipt of such report, the magistrate under section 191B may or may not take cognizance of offence. In other words, he is not bound to take cognizance of submission of the police report by the investigating officer. Hence, by directing the police to file charge sheet or final report and to hold investigation with a particular result cannot be construed that the magistrate has exceeded his power. Therefore, my humble submission is, even if charge sheet is filed, the magistrate should have rejected, should have compromised the matter, should not have taken cognizance on the basis of the charge sheet submitted by policeman.
Can be all examined at the appropriate stage, sir. We say permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of, the interim order is vacated. All right.
Item 72.
I plead your lordship. Lordship, here is a case where the petitioner has prayed for quashing of the criminal proceeding on the ground that section 3(1) Roman 10 of the SC/ST Act is not applicable in this present case. And the land dispute of the party is converted to the criminal proceeding. It is an abuse process of the law and the court. And the lordship find it's a the informant is encroaching the land of the government land, and there is a hue and cry. The matter was carried to the Tahsildar, and the IAC also intimated. And taking advantage of the caste, she has filed this case, and more particularly, the petitioner number 3 is an assistant public prosecutor of the JMFC court in Kujang, and taking advantage of the situation, this case has been foisted. Your lordship, kindly have a glance to the judgment of the apex court reported in. Your lordship may kindly have a glance to the live law. Your lordship may paragraph 3 from the bottom, 12th line from the bottom.
Yes.
Starting from the line from the aforesaid. Lordship, 12th line from the bottom.
Yes.
From the aforesaid, it seems that the private civil dispute between the parties is converted to criminal proceeding. Initiation of the criminal proceeding for the offence under section 3(1)(1)(b) and (va) of the Civil Cause and Civil Trial Prevention of Atrocities Act. Therefore, it is nothing but an abusive process of law. Quote from the materials on record, we are satisfied that no case of the offence on section so and so is made out, even prima facie. None of the ingredients of the section so and so are made out and are satisfied. Therefore, we are of the opinion that in view of the fact and circumstances of the case, the High Court ought to have quashed the criminal proceeding in exercise of the power on section 482 of the Code of Criminal Procedure. This is the law laid down by the apex court. In my case, it's a government land, and the informant is encroaching the government land. When the public protested, including the present petitioners, there is a misutilization of the provision on section 3(1) of the Roman 10 of the SC and ST Act.
All right.
It is an abusive process of court.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The
Lordship, can it be in a roster bench so that?
Sorry. Yes.
Dispose of.
73.
Dispose of.
Yes. Yes.
Item 73.
73, my lord. Matter has been closed, my lord. Criminal proceeding has been closed, your lordship.
All right. Petition has become infructuous, it's disposed of as such. All right.
Item 74.
Then appeal is dismissed. Interim order vacated.
Item number 75.
75 may please, my lord. Now, here is the petitioner is a proprietor of the rice mill, lordship. He is a miller. He challenged the initiation of the very criminal case under Annexure 1. My lord, the violation of the section is under section 7(e) of the EC Act and section 3 of the PDS Control Order 2008. Well, my humble submission before a lordship is under Annexure 3 and 4. The collector was session over the under 7 collector was session over the seized rice, and the gave a specific finding that this rice of the miller is not under the Essential Commodities Act. Lordship, kindly see the finding. Annexure 4, page 20. Annexure 4, page 20. Lordship, last 3 paragraph. I may be permitted to place. Thus, after going through on the documents and hearing the seized truck bearing number such and such is released and the seized rice is also declared as non-PDS rice. And hence this proceeding drawn against the Rajesh Khatan, the present petitioner, is not maintainable in section 6A proceeding. Thereafter, another case, Lordship, in respect to another 7A proceeding, Lordship, annexed to 3 page 17, Lordship. The relevant portion of the is page 19, last paragraph. However, it is to be noted that the shortfall supply of such and physical stock within premises of such and such differs only by quintal line. Hence, such and such found in OP number 2's house and could be bad quality rice supplied by OP number 3 as rice and paddy of Miller are not covered under the EC Act and OPH control order. The case against OP number is dropped. The COC is directed to surrender the such and such rupees collected through auction to seize price to the OP number 3. My humble submission before Lord is the seized right, which is subject matter of the FAR, is subject matter of the 7 EC Act before the competent authority under the Essential Commodities Act. The competent authority has reached a specific finding that the rice seized is a Miller rice is not covered under the Essential Commodities Act and under the OPDS control order. So therefore, if this view findings of the collector is accepted, then the none of the offences is created under the.
All right, permitting the petitioner to raise all please at the proper stage. The interim order is vacated. Okay.
Item number 76.
On behalf of Mr. Chand, Your Lordship. Your Lordship, this matter is under 138 of NI Act, Your Lordship. The petitioner was forced, the check was forcefully taken from the petitioner, Your Lordship.
All that's matter of evidence, sir. Permitting the petitioner to raise all please at the appropriate stage. The interim order is vacated. Right.
Item 77.
I'm challenging order dated 24/3/2017, running page 18, my lord. That allegation is that, my lord, the direction of the special judge, my lord, in that there 22,000 to the 22,000 presented to the accused number accused, my lord. In this case, the background of the case, my lord, that is the present opposite party number 2, my lord, implicated under section NDPS Act, my lord. And in the meantime, my lord, 21,000 as a recovery, my lord.
Maybe excuse for a minute. Yes. I may be excused for a minute.
Yes.
21,000 as recovery in the 21,000 recovery from the accused, my lord. The recovery, my lord, IO is a recovery. In that time, IO is a recovery. But inadvertently, I have mentioned in para 7, my lord, page 4, my lord. That is 22,000 I have mentioned in the. So far as in that region, my lord, the present accused filed an application before the special judge, my lord. That amount will be recovered, my lord, at the 22,000. And Lauren, special judge are directed to the present petitioner, my lord, to release the 22,000 and disciplinary proceeding against the present petitioner. That's why application filed before the honorable court.
It's all right. Permitting the petitioner to raise all please at the appropriate stage. Interim order is vacated. Right.
Item number 78.
Oblige.
None appears dismissed. Interim order vacated.
79.
May I please, Your Lordship, permitted to raise all the point court below.
Right. Permitting the petition. Right.
Items 80.
May I please, Your Lordship, my lord. The matter is related to quashing of a criminal proceeding, my lord. My lord, on the ground of my lord, the petitioner is not involved in this alleged crime at all, my lord. Kindly have a glance of Annex 1, page 8, my lord, FR, my lord. On the basing on the plain paper FR of IIC, the case was registered on dated 31/12/2016, my lord. My humble submission before Lordship, prior to that occurrence, the petitioner was in custody in another case, my lord. I have also annexed, my lord, Annex 2, my lord, in which case he was in custody 27/6/2014 and acquitted on 30th January 2017, my lord.
You can lead evidence or all that, sir. No problem. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. Interim order vacated.
Item number 81.
Let's 81, I am for the opposite party. None appears to the petitioner, dismissed on non-prosecution. Interim order of case.
Item number 82.
None appears, dismissed on non-prosecution. Interim order of case.
Item number 83.
May I please, your lordship. The petition has been discharged, my lord, in the criminal proceeding on basis of withdrawal petition filed by the prosecution under section 321, my lord. And then after the further proceeding is in self-serving offence has been proceeded on basis of the protest petition, my lord. Your lordship kindly glance to page 28, my lord, the order of 12/12/15, my lord. The case record is put out today in spite of third national local, in spirit of the third national local adalat. The learned APP is present and filed a petition under section 321 of CRPC and letter bearing in letter dated such and such dated ethic home prosecution case number GR case number 1 of 15 letter dated such and such.
302, sir.
My lord.
It's a 302 case.
Yes, my lord.
Yes, so you are the complainant.
No, my lord. I am the opposite, my lord. I am the accused, my lord. Yes, I am the opposite, my lord.
I know you're. No. So you're aggrieved by this order.
No, my lord. I am the petitioner here, my lord.
No. What are you challenging here, sir?
I am challenging the second cognizance taken, my lord. That is 1/6 case number 293613, my lord.
Right.
It is not permissible under section 302 of CRPC, my lord. And I have been discharged in the criminal charge, my lord, on dated 12/12/15, my lord.
What's your instruction, sir?
In fact, here they say.
Despite notice having been issued on 16/11/2017 till date, no reply has been filed. As a last chance, reply be filed on or before 3rd April 2023. List before the roster bench on 10th April. Interim order to continue.
Item number 84.
84, your lordship, Mr. Pinaki Mishra will appear in this matter. Okay, only next week, my lord.
No.
Next Friday.
No, not adjourning it, sir.
Next Friday, your lordship.
No, not adjourning it, sir.
There are some personal difficulties. Opposite party number 2 has also been not appeared till date, my lord.
Permitting the petitioner to raise all pleas at the appropriate station in the trial court. The petition is disposed of.
My lord, may I pray? Can I?
Is there anyway no interim order here, sir?
No interim order is there. My lord, we will file a better application here.
Then you withdraw it. Counsel the petitioner seeks leave to withdraw the present petition.
With a liberty to file a better application.
Not application, to liberty to seek appropriate remedies, other appropriate remedies in accordance with law.
Deeply obliged.
Disposed of is withdrawn with liberty is paid for.
85.
Yeah, for the opposite party. No instructions, dismissed. All right. Memo taken on record. All right. 86 also same.
Item 86.
86 also. Right. Same here. Yeah.
Item 87.
None appears dismissed. Interim order.
Item number 88.
My lord, I am for the opposite party, my lord.
All right. None appears to the petitioner. Dismiss the non-prosecution.
Item
Interim order.
number 89.
None appears, dismiss the non-prosecution. Interim order.
Item number 90.
No instruction. No instructions, dismissed. Interim order.
Or orders item number 1.
May I please, your lordship? I am for the petitioner. Your lordship, just have a glance to order dated, order number 37 dated 2/12/2022.
Yes.
My lord. The employee won the case in the year 2012. And for your lordship's review has been filed by the opposite party. It was not being listed. And I am highly obliged because of your lordship that was listed and review dismissed. Thereafter, order is to be complied. Chancellor office has written a letter to the university authority and government to implement the order. For that reason, your lordship on the last occasion has passed the order. Learned additional government advocate for the state states that he will seek instruction on the present status of complaints of the order of this court in respect of annexure 4 of this application. Your lordship just have a glance to annexure 4 of that. With your lordship's permission, I am placing a small 4 or 5 lines.
You file. Okay, who's for the other side?
Well, that is government took time last occasion. 11 years your lordship passed. Order is not being implemented. That is retired fellow.
Notice, Mr. Kunti accepts notice.
Yes, my lord.
The and takes time for instructions. List on 10th February.
And in the meantime, your lordship.
I'll take this.
Item number 2.
In item 2, my lord, I have filed an IA.
Your lordship, he served a copy just now in court, Millard. A copy was served in court just.
Anyway, they just want that.
This
That
now
should
your
be
lordship-
opposite party 4 instead of opposite party number 1.
Yes, that's.
Your lordship kindly recollect, there was a lengthy submission on that day. And your lordship directed state government to pay. And your lordship asked if the state government will pay, what is your objection?
Your lordship, paragraph.
That was
Your lordship has. Paragraph 2 of
You have not served copy on me.
my lord's
He is
order.
supposed to see a copy on me and is claiming relief against me. And he has not served copy. Your lordship kindly recollect.
Your lordship,
Lengthy argument.
number 5, your lordship had directed. Your lordship, for moment, your lordship, see paragraph 2. Your
Paragraph
lordship-
2.
Yes, paragraph 2 of the order, man. The was successful for 5-year course in biotechnology at Gandhi Institute of Engineering, Gunpur, Raigada. A government in that your lordship under impression that is a government institution. That in fact that is not a government institution, that is a private institution and now declared as a deemed university.
This GIET is not a government institution.
No, my lord. So that that is my for that reason I have filed this IA. So they have received the amount, they have to return.
No.
And your lordship may see also prayer in the writ appeal. He has not made a prayer against us. The entire prayer is against the opposite number 3 and 4.
The
So instead of
judgment.
one,
So if it is if it's not a government institution.
Kindly, Millard, your lordship kindly consider, at that time lengthy argument was made and they have given, JE is given a ticket to me to admit as a general candidate. We have admitted. And we have supported when he has said that one tier-up candidate left and you claimed that. And we have forwarded it to the JE that you kindly consider is the claim what to do. And that is our case. We have supported the petitioner.
No, that's right.
Now, Millard, if your lordship, this is a thing, when after lengthy argument, your lordship kindly see the single judge judgment and the counters filed by the state and JE. They say he is not entitled. When your lordship that time said that he has anyhow, he has got this TRW, this thing, and he has not got state to pay. And the interim order also there. Interim order also there was a direction that in case it be abide by the result of the. And after your lordship, that is a lengthy submission. I have placed the entire thing. And if even I have got the counter now.
Anyway, the waiver has to be done by you only, correct?
Yes.
no. Because here the institution who has received the amount, they have to return it. And you'll also see the prayer in the writ appeal.
Tuition fee waiver is under the scheme of the government that any institution.
No, the tuition fee paid by him was received by whom?
My land.
Institution.
By institution.
Yes.
All right.
It's under.
That's very simple. So then if it has been received, the government pays back.
And just enrichment by the
of the institution.
Correct.
sir.
That is obvious. If he has paid it to you, you have to pay it back.
No,
As per the order,
Payment is not
deposited.
No, sorry, kindly.
In the protest, I have deposited the money in the writ appeal that the order has been passed. No, but with whom? With the institution? With the institution?
Yes. No, Millard, your lordship has seen the single judge order, Millard, very clearly written, and the counter filed by the JE and the government. They say he is not entitled. And we have said, after getting that, we have got JE has issued a letter to the institution to admit him as general candidate. We have admitted him.
All right.
Admitted him. Thereafter, Millard, he came to know somebody else, junior to his, somebody who got less mark, he got the tier up. So he was represented to the institute, the claim. Then we have forwarded his application. And they have justified why he is not entitled, both state and the JE. He has just now served a copy in the court. Your lordship, kindly, I will say, no, I am not standing on the, not is a strong amount, but it is a thing. The JE and state government filed counter, lengthy counter giving the statutory provisions that he is not entitled. And it is not entitled because number of persons above him, they have not got the benefit. At that time, your lordship said, yes, if that is so, state government, because tier up scheme is state government, and they have allotted, but they have given wrongly to these things, said they have to pay. When I said, your lordship said, if the state government pay, what is to you? Then I said, let me the direction. That was the direction. Millard, I only player is Millard, one. Just now, a petition was filed claiming he served copy just now. I have not seen the copy. I have collected it from him. And your lordship kindly give a short time, and I will place the matter. If your lordship feel that the institution is liable, I have no objection. In view of the counter filed by the state and JE and the case of the petitioner, I am not entitled. I was given a general candidate, and JE was given a ticket to admit him in general candidate. We have admitted him in general candidate. TRF, we have nothing to do.
The present application has been filed by the state government seeking modification of the order passed to this court on 20th October 2022 in writ appeal number 26 of 2017 only to a limited extent. Full stop. By the said order, the court had directed the tuition fees paid by the appellant will have to be refunded to him by the state within a period of 8 weeks, failing which the amount will be paid together with simple interest at 6% per annum for the period of delay. Paragraph. This court had issued the direction on the basis that the institution, that is Gandhi Institute of Engineering and Technology, bracket GIET, Gunupur in Rayagada, was a government institution. Full stop. It is now apparent that it is not a government institution.
It is deemed university taken.
It is a deemed university. Full stop. Paragraph. Secondly, it has been affirmed, it has been confirmed by counsel appearing for the appellant that under interim orders of the learned single judge, the appellant in fact, of the division bench, the appellant had in fact paid the tuition fees under protest. Full stop. He confirmed that the fees were in fact paid to the institution, that is GIET.
There, Millard, order is interim order is interim order is Millard, that it is abide by the result of the writ appeal.
Correct. And that payment was to abide by the result of the appeal.
So
full stop.
Your lordship
No, let's not.
the same, Millard, your lordship may dictate the same order. He has given a copy to me. I have to intimate, I have intimated already the judgment.
That view of the matter.
Now I have to, Millard,
That view of the matter.
instruction from him.
All right. All right.
I have sent the brief to them, judgment to them.
All right.
Now he filed a petition, let him serve a copy, just now served, and your lordship breathing time. Make a
That view of the
submission.
matter, the order passed by this court on 20th October 2022 is modified by directing that the tuition fees paid by the appellant under the interim orders of this court, which were in fact paid to the GIET, will be refunded to him by GIET within a period of 8 weeks. Full stop. The period of 8 weeks will begin to run from today. Full stop. If it is not paid within 8 weeks from today, the amount will be paid by GIET to the appellant, together with simple interest at 6% per annum for the period of delay. Full stop. Paragraph. A copy of this order will now be sent to the GIET by the registry by a special messenger for compliance.
My lord, may,
Full stop.
may submission, my lord, respondent 3 and 4. They are the Dean of Administration and Principal.
So we have said GIET.
GIET
Who
means-
will the GIET should pay is for GIET to decide. All right.
So in case they will not pay, but in case of contempt.
Sir,
that
you want me to give
for any.
You want me to give legal advice to you?
No,
Not necessary, sir. If we say that the institution has to refund, it's better that we leave it as.
So my lord, another prayer, my lord. Lordship, I have deposited the interim order of some portion of the amount.
Whatever, you say whatever has been, no,
Interpretation fees.
whatever you have paid, we'll get back, sir.
Whatever I'll pay.
Only whatever you have paid.
Right.
The tuition fees, comma, to the extent paid with the appellant, bracket, comma, will be refunded.
May your lordship kindly say that I have received application. Otherwise, my lord, I have sent it, they will misunderstand me.
All right.
Your lordship said that they have served copy in court.
All right. All right. Right, sir. Right.
My lord. Copy served in court to me.